This is a Human Rights Tribunal case brief presentation between Paul Edward Witkowitz and University Health Network. The applicant, Paul Edward Witkowitz, filed a charge under Section 4.5.1 of the Human Rights Code. The relevant law in this case was dealing with the abuse of process, discrimination with respect to employment because of disability contrary to the code. The applicant started working in 1993 at the respondent, the Unity Network at a hospital. In 2011 and June of 2012, the applicant had a drinking problem and asked the union representatives for help. The respondent suspended him from working for 5 days, then sent him to a rehab program for the second time. Later that month, the applicant returned to work, but still had drinking problems. On September 6, 2012, the applicant's employment was terminated. On September 11, 2012, a grievance was filed that stated termination was without just case, based on disability, and was a violation of the Human Rights Code. The demands of the grievance was that the applicant should be reinstated immediately without lost wages, benefits, and seniority. On November 23, 2012, the union representatives and the hospital, the respondent, negotiated a settlement that was accepted by the applicant. The terms of this agreement were the following. The applicant would have nominal reinstatement of the employment, not permanent, of 60 days so that the applicant could apply for early retirement, a lump sum payment of $10,000, and the hospital would provide a letter confirming the length of employment until the date of his retirement, plus the position he held, and with no adverse statements. This was all accepted and signed by the applicant. The applicant then claimed that he was not sober during the hearing on November 23rd, and that he didn't understand what he was signing for. The applicant says that he told the union representatives that he was tired and thought they would understand that what he meant was that he was drunk. He thought the meeting was about his sobriety and that it was about the hospital giving him time to go back to rehabilitation. He thought that if he came back in 2 to 3 months, the hospital would consider his reinstatement into work. The union representatives disagreed with the applicant's statement that they should have figured out that he was drunk, as everyone thought he was fine that day. 2 witnesses provided by the respondent also testified that the applicant did not seem at all drunk that day. The union reps said that they told the applicant that if the hospital ever did decide to take him back, he would have restrictions and certain requirements regarding his alcohol abuse. The judge decided to dismiss the application because the applicant's evidence was inconsistent and vague, and there were reliable witnesses that stated the applicant was in the wrong. The judge felt that the terms were explained to the applicant and he understood and accepted them, and that the evidence does not establish an inability to understand the settlement discussions. Therefore, the case was dismissed. The issues involved in this case are: does the respondent have an issue of discrimination with respect to the Human Rights Code? Did the applicant fulfill the requirements for his charge of violation of the Human Rights Code? Was there enough proof provided by the respondent showing that the applicant has falsely accused the respondent? The final decision of the court was that the charges of discrimination towards the respondent, contrary to the Human Rights Code, were dismissed. This means that the respondent was not guilty of charge. The court talked to both union reps to establish the sobriety of the applicant. They also talked to the applicant to get his side of the story. The court talked to 2 of the witnesses provided by the respondent. Once the court had all sides of the stories and reliable evidence, the judge decided that the case should be dismissed in accordance with Section 45.1 of the Code because the respondent had already appropriately dealt with the matter. I agree with the court's decision to dismiss the case for reasons that there was no evidence of discrimination towards the applicant. I believe that the applicant was in the wrong for many reasons, such as he was given a fair package considering he was drunk at his workplace, and that he manipulated everyone by claiming that the union reps should have understood that he was drunk on the November 23rd hearing. Furthermore, I think that the respondent followed exactly the protocol required to deal with this case and not bring it to court.